Good afternoon and welcome to the Appellate Division, First Department. I will let you know that we have more than 5.5 hours of argument time requested, so I'm going to ask that you ask for the time you need, not the time you want, understanding that the light is for you, not for the court, so that if my colleagues have more questions, I will allow them to continue. All right. We have some visitors. Have they arrived yet? Here we go. Yes. Good afternoon and welcome. This afternoon, we have 3 visiting attorneys from China, ni hao, and several interns from 60 Center Street. Welcome. We are happy to have you here, and we hope you enjoy what you see. All right. People versus Devon Best Kelly. Okay, submit. MT Children is submit. Catronio versus Van Wagner. I'm sorry if I mangled the name. All right. Do you want rebuttal time? 5 and 2? Okay, and plaintiff? 3 minutes. Thank you so much. AMF Trust Ventures versus I-80 Group and Hemingway Group versus I-80 Group. Those cases will be argued together. I will hear from the parties. Okay. Okay, so we don't do share. So tell me how many you want and how many he wants. That's how we do that. 5 and 5 is not 8. So we will do 4 and 4. Okay. All right. Thank you so much. People versus Albert Holquin. Good afternoon. 2 minutes to address the intervening decision. Okay. And the appellant is not here, so 0 and 2. All right. Partners for payment, D3 versus Crooks.
Good afternoon, Your Honor. Plaintiff appellant, 5 minutes and 2 remaining.
Okay. Okay, let's do 5 and 1 and 5. Malave versus Kinney. And what? 1 minute. Okay. Okay. Okay, 5 and 1, 5 and 1 and 6. 134 Lexington versus Bawani Ma is submitted. Icon Partners versus Alliance Bernstein.
Sean Murphy for the appellate, Your Honor. We request 6 and 2.
Okay. All right, let's do 5 and 1 and 5. Bethpage Federal Credit Union versus BR 52. Okay. Okay, let's do 3 and 4. Okay. People versus Quintin Rodriguez. Okay. All right, 5 and 1 and 5. Lotrian versus 3M Company.
Good afternoon, EIDP Incorporated. We would request 3 and 2.
Okay.
Present Inc. 3 and 2.
Okay.
Your Honor, for Ristoli and appellant, 5 and 1.
Okay.
Susanna Chester for Mr. and Mrs. Lotrian, 10.
Okay, so we'll do 5 and 1, 3 and 2, 3 and 2, and 8. Caldenas versus New York City Housing Authority. Who's the appellant?
Plaintiff appellant requests 7 and 2.
Okay.
Defendant
Did you have a cross appeal? Yes. Okay. Okay. We're gonna do 5 and 1, 5 and 1, and 6. Panels versus Panels is submitted. Tavares versus Tuck It Away is submitted. First case argued on the calendar is Petronio versus Van Wagner. Again, my apologies for the pronunciation. You may proceed.
Good afternoon. Daniel Wright on behalf of Milburn Macris, Posadas and Sidon for third-party defendants need. Your Honors, as you're well aware, this appeal is solely on the issue of whether the plaintiff sustained a grave injury, and on that issue of whether the plaintiff is rendered completely unemployable at this time. You'll hear the respondents argue that this is solely a simple a case of competing experts. That's just simply not the case, and that's exactly how the lower court was misled in the underlying motions. If you look at defendant respondent's expert, they actually found that there is no traumatic brain injury. And if you look at plaintiff respondent's experts, they crucially never considered, as the lower court did in their decision, plaintiff's own admissions in his testimony that he continued to work and finished out the project.
Counsel, let's assume that your client met its prima facie burden. Let's assume that. It seems to me possibly, there's an issue of fact, particularly when we're looking at Dr. Pearl. I think is it Pearl or Perel?
Perel.
Okay, Perel, I believe he treated the plaintiff, June of 2024, and indicated based upon, the treatment that, the plaintiff was significantly disabled. So it just seems to me it's an issue of fact. No?
Right, but the Dr. Perel and the other experts that plaintiff relied upon, they did not consider plaintiff's own testimony that he was able to continue to go to the gym, drive himself. So their expert opinion isn't probative.
Is that an issue of credibility, though?
As,
Or as to the plaintiff, I mean, the doctors are saying one thing based upon medical evidence in their evaluation of him, and his testimony can be weighed by the jury in light of that.
I believe it raises an issue of credibility for the experts themselves for failing to consider plaintiff's own admissions in his testimony that he can function. He actually did look for further employment at one point. He continued to go to the gym. He continued to drive himself around. He clearly has a level of functioning that the experts are ignoring, and that the lower court completely failed to consider in their...
I'm not sure about that because if my memory serves me correctly, I believe that the expert conducted about, 15 tests and really, well, let me say it this way, conducted 15 tests, right? And it was to assess his current condition, future, potential rehabilitative needs, et cetera, et cetera. So it seems to me that what I said about, June 2024, right? That we're looking at the treatment and those 15 tests.
Up until 2020, all MRIs and evaluations by other doctors were completely normal with no evidence of a TBI. So again, I don't believe that plaintiff's expert, who is going against plaintiff's own admissions, not acknowledging that plaintiff had normal tests up until 2020, they don't have appropriate value in their expert opinions. Also, the Perel and these other experts are noting, seizures and headaches and depression. Some of those conditions already pre-existed the accident. On top of that, it's those conditions are not sufficient enough to find that he is completely unable to be employed. So if you have no further questions, I'll
Thank you.
Thank you.
Your Honors, I'd just like to state that I'm not going to need the majority of my time that I had asked for, because Appellant has clearly set forth why the lower court decision should be upheld. Because the competing expert decisions and their credibility is a question of fact. And that is an issue for a jury to decide and not for this court. Whether appellant believes that Dr. Schuster or Dr. Perel took the totality of plaintiff's condition prior to this accident into consideration when rendering their opinions, their expert opinions, that is properly addressed not before, Your Honors, that's properly addressed before a jury. And whether or not those were taken into consideration is properly addressed in a cross-examination by appellant's counsel. Workers' Compensation Law, Section 11, states that whether, a brain injury, it's whether or not the injured party can be employed in any capacity. Whether or not that this person tried and failed to get employment with the existence of this brain injury does not change the fact that the issue is whether or not they can be employed in any capacity. And at this, I will yield the remainder of my time.
Thank you so much.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. I'll be brief as well. I did want to point out one thing. Plaintiff's been treating since 2014, and when we're talking about ignoring evidence, the defense experts, from what I saw in the record, kind of ignored the diffuse tensor imaging study, which actually gave a diagnostic explanation of what happened here. And I know you know this, you facts probably better than I do, but look at 1491 to 1492 of the record. That's the actual report of Dr. Golzat. He explains why the condition is progressive and deteriorates over time. And specifically, I'm asking you to look at paragraph 1 on 1491, and then paragraph 2, which carries over to 1492. One other point, if you have no question, I'll sit down because I know you have a busy calendar. I've got a 60-year-old electrician with tons of problems. The defense expert, from what I read, said that he was employable doing electric work. Now, I don't think I'm stupid. I can't do electric work. I don't think somebody who's got tinnitus, who's got headaches, who's got depression, who's got all kinds of executive functions is employable as an electrician as a matter of law in connection with a summary judgment motion, and I think the trial court got this one right on the head. So we would ask you to affirm, and thanks for listening to me.
Thank you. Counsel?
I'll just keep it short. The DTI results are, they're not generally accepted for proof of TBI. Along with that, I would just direct the court to its own decision in Arum, let me get this right, Arum Baru, where evidence of conditions of seizures, headaches, depression, the court still found that there was no evidence to specifically show that the plaintiff was unemployable in any capacity. On top of that, even if the court were to find that there were issues of fact of whether plaintiff sustained a brain injury, there are no issues of fact raised by the expert opinions as to plaintiff's employability and rendering the plaintiff completely unemployable. So on that, if there's no further questions, I'll rest on my brief.
Thank you so much. AMF Trust Ventures versus I-80 Group and Hemingway Group versus I-80 Group.
Your Honor. May it please the court, Tom Cawley on behalf of the defendant appellants. Whether defendant Hawani acted reasonably in redeeming plaintiff's investments and returning their money to them is a jury. There's substantial evidence in the record that Hawani acted reasonably in redeeming plaintiff's investments. Over a 6-month period, plaintiffs threatened to go to the press. They criticized I-80 manager and I-80 GP to other investors. They maligned Hawani communications to other investors, and they threatened to sue I-80 manager and I-80 GP. It is also undisputed that plaintiffs disclosed confidential information, which is precluded by the agreement that the plaintiffs signed. And they shared that confidential information with third parties in clear violation of the confidentiality agreement. The trial court simply concluded that Hawani could not redeem plaintiff's investments because they were, quote, vindicating their rights under the agreement. But there's nothing in the parties' contract giving plaintiffs the right to engage in conduct detrimental to IAD manager and IAGP if they were vindicating their rights under the agreement. In any event, this court previously held that the plaintiffs had no rights under the IAD-GP agreement, and so there was no rights to be vindicated. Plaintiffs claim that they were redeemed a retaliation to them for not agreeing to a restructuring of I-80. But plaintiffs were redeemed 6 months after they rejected the offer to restructure their LLC agreement. And during that 6-month period, plaintiffs threatened to destroy I-80. In short, this is a jury question that should be decided by a jury and not as a matter of law.
With respect to the redemption notice, did it indicate disclosure of confidential information?
It did not, Your Honor. But both experts agreed that you don't have to put everything in it. You're talking about the notice for when they were redeemed. The
Yes.
notice that went to them. No, it did not. It just talked about disparagement. But both experts agreed on both sides that that notice doesn't have to be all-inclusive of all the reasons, nor does the contract say that any notice has to be all-inclusive. So it was clear, though, Your Honor, that Mr. Hawani knew at the time that he redeemed them that they had disclosed confidential information. They had told Mr. Hawani that they were going to, I think they said, family offices around Wall Street, showing around confidential information. And the agreement precluded them from showing any information relating to I-80 GP or I-80 manager, and they violated that.
Because the reason why I asked that question, because I thought I read somewhere in the record, there was testimony that it was industry practice in the financial community to really list all of the reasons, you know, because that's so, what's the word that I'm looking for? You know, it's such a serious action that you really want to list everything in that notice. I thought I read something like that.
Your Honor, I think it's to the contrary. I think that, first of all, I think it's a jury question, because I know our expert testified, I think their expert agreed, is you don't have to have an exhaustive list in the redemption notice. And also, Your Honor, what this involved here is simply giving them their money back and saying, if you want to invest, go somewhere else. So it is a serious action, but it's just a matter of a partnership, an LLC agreement with their members, and the manager saying, what your actions are detrimental to us. The notice did say disparagement, and that was clearly in the notice, and go somewhere else. Here's your money back, have a good day. And so it's been characterized as serious, but they got their investment money back. And moreover, Your Honor, the issue of whether the exhaustive nature of the list would be a jury question. And our witness, I am sure, and I think their witness agreed, that those lists do not have to be exhaustive.
Well, Counselor, whether the redemption was based on reasonable excuse, or did Mr. Hawani have named some reasonable facts that would cause him to redeem?
He did. In the notice said disparagement. And so
So I think I read that they threatened to go to New York Times
Correct.
and New York
Wall Street
Post.
Journal, right.
But Mr. Friedler said they didn't.
Well, first of all, I think it's undisputed in the record that they did. They told, in fact, there's testimony in the record that Mr. Hawani was told that we're going to go to the Wall Street Journal, or we're going to go, I think it was the New York Post. So he was told these things, and it's a jury question as to, you know, if they claim that they didn't, but there's undisputed evidence that Mr. Hawani said, I was told that they're going to go to the press, I was told that they were going to sue, I was told that they were going to blacken our name, I was told that they were doing whatever they could to destroy our business. They clearly talked to other members to try to rile them up against Mr. Hawani. And the test in the agreement says if the acts committed are detrimental to the company, I-80 GP or I-80 manager, that is a basis in his reasonable judgment to return their investment and say, invest with someone else, you can't invest with this company.
What evidence did he put forth with that redemption notice that showed that it was detrimental to the company?
Or has
there been anything submitted?
There was, all that the agreement required is a notice, right? It doesn't require putting forth evidence. It just requires, the contract requires you give them notice, a certain period of time, I don't know if it's 30 days or whatever, that you give them notice that they have committed acts that in his reasonable judgment, it doesn't even say what the notice has to say, but if he concludes in his reasonable judgment that they committed acts detrimental to the company, that he has the right to return their investment. There's no criteria in the agreement as to what he has to delineate. The facts are clear. The facts are that they were disparaging the company. The facts are that Mr. Hawani reasonably believed that they were taking actions that were detrimental to the company. And so that is all that's required. The second point is the issue of the contract. And the contract here, you have to look to it's the ID manager contract. The court has already decided the IDGP agreement, says that related to just investments in the fund. The management contract says that the plaintiffs are entitled to fees that are made by I-80 manager. And the undisputed evidence is the fees that they are seeking here were not made by I-80 manager. The fund was a different fund. It was the Iconic Fund. It was managed by a separate fund or separate management company. Nothing in the agreement says that they were entitled to receive fees from a separate management company. In fact,
Thank you.
need
You'll
no-
have time on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court, Michael Hannon on behalf of the plaintiff and respondent Hemingway. Your Honors, it was objectively unreasonable to terminate Hemingway for resisting the defendant's repudiation of its contractual rights in this case. The relevant facts, as Your Honor's questions were suggesting, are not genuinely disputed. The defendants here terminated Hemingway because it refused to execute these proposed amendments that would have stripped it of its rights. There's no dispute that all the disparagement came after Hemingway refused to execute these agreements that were rewritten by the defendants to change their meaning. This 6-month delay is a red herring. The defendants rescinded Hemingway's right to accept these changes literally days after Hemingway refused. There was a telling recognition in the argument below where defendants' counsel here acknowledged the defendant's position, which was, if you want to sue me, go ahead, but you're out of the fund. That's not objectively a good faith reason to terminate someone if their lawsuit proves to be well-founded. The termination notice claimed that Hemingway was disparaging and threatening to defame I-80 Group, but defendants acknowledged that the only disparagement by Hemingway concerned the repudiation of the agreements, and the only threats by Hemingway were threats to vindicate its rights under the agreement. That's affirmed by the affidavit that the defendant submitted on appeal. There's also zero evidence in the record of any actual disparagement or defamation. The self-serving testimony of defendant Mark Helwani is completely unsubstantiated. There's no corroboration. There's nothing in writing. As Your Honor suggested, that there's no evidence of harm whatsoever. No evidence of anything detrimental. It's ultimately irrelevant, though, Your Honors, because what defendant Helwani labels as disparagement and threats to defame were, in fact, Hemingway discussing the proposed amendments to this management agreement with other Class B members. What's going on here? What do you guys think? With his financial advisors. Am I reading this correctly? Can this really be the repudiation of my rights that it appears to be? This made-for-litigation argument that Hemingway shared confidential information really underscores the total lack of evidence to support any good faith reason for this termination. Confidentiality was not a stated reason for termination in the termination notice, and it is industry practice to include everything in this termination because it is a serious event. Terminating Hemingway and returning his money.
But why isn't that a question for the jury to decide?
Because the defendant has put forth no evidence whatsoever to support that question. There is absolutely no specificity or evidence about what Hemingway shared or with whom. What's the confidential information that he shared? It's not on the record.
Excuse me, but aren't there text messages going back and forth? For example, there's a February 2022 text message between Friedler and another investor that criticizes Helwani.
Your Honor, I'll let my colleague address that because Mr. Friedler, I don't represent him. I believe that post-dated this discussion, but I'll let him, if I may.
course.
Thank you. It's also worth noting, Your Honors, that these agreements expressly permitted Hemingway and Mr. Friedler to discuss these documents with their financial advisors and other Class B members. There was an express exception to the confidentiality agreement. In any event, I'm not even sure that these amendments would have been covered by confidentiality because they were proposed. They were simply the defendant's attempt to rewrite the agreements. With respect to the contract issue, Your Honors, the court previously held that the agreement that governs the I-80 Group Management Company unambiguously states that members like Hemingway were entitled to a pro rata share of all income or fees generated by providing investment management services. In other words, that Hemingway is entitled to all the income and fees generated by the entity formed by the I-80 Group to conduct this business.
Thank you.
Well, where,
Go ahead.
where in the record is it implied that Mr. Hawani has agreed to give Class B investors a collective 31.5%? I believe a 7% was offered.
Your Honor, there's nothing in the record to suggest that 7% or any amount was offered to my client. That's a fiction. And what the record reflects is not a 31% or 5%. It's the pro rata share that my client bargained for at the outset of the Class B membership rights. To the extent that the defendant wanted to change those agreements in order to accommodate something new, it was his obligation to address that with his initial investors with whom he had an agreement, not to simply rewrite them and impose new terms on his original investors. Thank you, Your Honors. Unless Your Honor has another
You
question.
have anything else?
No, thank you.
Thank you, Your Honors. This is Brian Hale from Allen Atkins, and I represent AMF and Sunscape, and that is Mr. Friedler in the case. And I'll start with your question, Justice, which is that February 21 communications between Mr. Friedler and actually a business partner of his, who is an LP in the fund. And actually, there is no evidence in the case, and it could not be the case, that Mr. Helwani even knew of that communication. It was uncovered during discovery. That was not something Mr. Helwani could have based his decision on. And in fact, if you go back and you look at what happened with Mr. Friedler in this case, he had a $3 million investment in the LP, which we pointed out, which gives him a different economic incentive. He has zero incentive ever to impact and detrimentally affect the I-80 business. He has $3 million of money, not just in the management company, but also in the underlying fund that's tied to performance. And the testimony in this case, which Mr. Cawley doesn't like to go back and actually look at, is that Mr. Friedler and Mr. Helwani actually didn't talk after December. They had a series of communications through lawyers in December, and then what happens? They don't speak again. So this whole great smear campaign, et cetera, if you go back and you look at the actual testimony, Mr. Friedler denied it. Mr. Helwani can't really recall it. He seems to think he heard it, maybe something from somebody else, and the testimony of that is there. So it doesn't present a fact issue. You roll the picture forward, and there's this 6-month gap. Why? Because there's another group of people out there, another group of Class B investors who won't sign on. And he actually is, if you look at the text messages that we cite, they're worried they're going to get sued by that group of people. So it's not just a problem between these two clients and I-80. It's a problem actually that Mr. Helwani has with a whole different group. That group signs on, the clock's out, he terminates both my client and the Hemingway plaintiff.
So is it respondent's position that they would be entitled to fees from any new funds that Mr. Hawani opens?
Well, there's two different types of fees, Your Honor, but the short answer for the management company, I think that's exactly right. That's exactly what Mr. Helwani told Mr. Friedler and exactly what's in the messages. He says that the IM, which is the I-80 group, the I-80 group investment manager, remains the same no matter what funds we do, which is you open an investment fund, and that investment manager, think of it sort of an office operation that generates and is paid an investment management fee, receives the fee. We then get our revenue share, being my clients and the Class B members. And his words to my client were the investment manager always remains the same. And it wasn't just to my clients. It's to other people, other Class B members. I think we pointed out in our papers. He called it a perpetuity. We have an affidavit from Mr. Helwani's partner, Chris Aristides, who said that that was always going to be the deal, that our clients had revenue from all funds for all fees generated by all funds.
How does this court's decision on the motion to dismiss factor into your argument?
I'm sorry, the motion to dismiss.
The prior decision?
Prior decision. There was a motion to dismiss. This is summary judgment now.
Correct.
Right? In our motion to dismiss, we addressed this particular issue. I'd like for you to address our decision, if you're familiar.
Oh, sure, absolutely. So in your prior decision, this court drew a distinction between the investment management side. There were two entities in which both of our clients bought into, the investment manager and the general partner. And they had different documents. The language of the fees to which they were entitled were different. And on one side, the general partner said you were entitled to fees from a particular fund, which was capitalized and actually defined as a fund. This court found that the different language in the investment manager didn't limit the fees just to one fund. It limited, on the GP side, in fact, it did. So what this court then did was said the GP document, because it was so drafted, is not part of this case. The investment manager, because it's not so limited, we were entitled to fees from to investment management fees from those other funds. Now, that's consistent with what this court decided on the good faith and fair dealing arguments, I think we pointed out in our papers, and also what this court said in connection with the fiduciary duty arguments, that was the intent of this court. And in fact, if you look at what this court did on the good faith fair dealing argument for the GP, it expressly said there was no good faith and fair dealing argument for the GP because it was limited to one fund. Obviously, that's not the core. If the IM were in that way, this court wouldn't have had that decision before.
Thank you. You have 2 minutes.
So, Your Honors, the relevant provision for the redemption is in Section 3.8, and it clearly says that the manager may require the complete or partial withdrawal of a member on 5 days written notice if in his reasonable determination it's detrimental to the company. So there's no requirement that there be injury to the company. There's no requirement, and this is a relationship governed by contract. There's no requirement that they delineate all the reasons, but there is substantial evidence in the record of reasons. And there was a threat to go to the Wall Street Journal and the Post that was made by Mr. Weprin, who's the representative from Hemingway, that Mr. Ariel Friedler from the AMF would do that, would go to the papers. There was discussions with Mr. Hawani. They were going to blow up the company. They told Mr. Hawani's associate they'd go to the Wall Street Journal, and they admitted that they would have bad publicity. They say that in their own papers, that they would create bad publicity for the companies.
Counsel, that may be reasonable subjectively to Mr. Hawani, but objectively, as respondents say, the redemption came after the threat of litigation.
Well, they threatened litigation, right? But they did all these, they threatened litigation way back, right? And then they're doing all these things while they're members of the company. They're threatening to go to the paper. They're threatening to destroy his business. And he has an obligation to protect his fiduciary duty, and if he has the right under the agreement to redeem them if he thinks their conduct is detrimental to the company. They can go off and sue, of course. If their conduct is hurting the company, he has the right under the agreement to redeem them, and that's what he did. And he knew all these things, and that's why he did it.
Well, you understand that their claim is that the redemption is retaliation, and you're suppressing their right to go to litigation.
Well, we're not suppressing their right. They always have the right to go to, we're not suppressing anything. They had the right. They're hurting the company. We have the right under the agreement to tell them to go, good luck on your lawsuit, but you're no longer vested because the conduct you're threatening to do is going to hurt the company. You're threatening to blow up the company. You're threatening to go to the papers. You're talking to other investors. Those acts are detrimental to the company. And that's a right under the agreement he has to withdraw them. Give them their money back, and you can go invest with somebody else.
Thank you. You have any other questions?
Jen?
You sure?
Yes.
Okay. All right. Thank you so much. People v. Albert Holquin.
Good afternoon, Your Honors. May it please the Court, Nathan Morganti on behalf of the respondent people here. Vascateles, just decided by this court, did not consider the arguments that the if-directed language renders defendant's challenge unripe, as there's nothing in the record that suggests defendant had been directed by his probation officer to avoid gangs, and Vascateles did not consider that the same language necessarily would make the condition reasonably related to his rehabilitation, as a probation officer would have to direct defendant to specifically avoid gangs particular to his circumstances. Admittedly, there is no alleged gang affiliation here, but it is just common sense that if anyone were to affiliate with the gang members or fly in the colors of a gang, that would harm their chance at rehabilitation. And since these restrictions would only go into effect when a probation officer sees the need to give that direction, it would become necessarily related. And Your Honors, I think the other conditions of probation actually reflect this very well. Specifically, the if-directed language is used in 5 other conditions, and I'd like to direct the court's attention to condition 9. Keep a curfew if directed by the Department of Probation. Obviously, not all crimes are committed because of the time, but this condition is in place because it gives the probation office a flexible tool to use. And that's what the court did here. It gave the probation officer a tool to use. It did not then require the probation officer to use that tool. And I think that's what really separates this conditions from other ones that this court has found not reasonably related. And I think that the standard here is just that it is reasonably necessary to ensure the defendant will lead a law-abiding life or to assist him to do so. And obviously, by keeping defendant away from gangs and gang members, it would do such a thing. And of course, if defendant were to actually want to challenge this condition, he could do so through a modification procedure after his probation officer has given him the specific direction to avoid a specific gang via colors or via association. If Your Honors have no questions, we would ask that you affirm.
Thank you.
Thank you.
Partners for Payment D3 versus Crooks. You may proceed.
Good afternoon, Your Honors. May it please the Court, Seth Weinberg for plaintiff appellant in this matter. As I'm sure Your Honors are well aware, the issue before the Court today is the sufficiency of service upon Christopher Crooks, who is a defendant in this foreclosure matter that was commenced back in 2013, and whether that service was sufficient under CPLR 308, Section 2. Specifically, Your Honors, the plaintiff appellant's position is that this decision dismissing this foreclosure action for lack of personal jurisdiction should be modified, at the very least, to send this case back to the trial court for a traverse hearing to be conducted because there is clearly an issue of fact concerning service that occurred in this matter. Specifically, Christopher Crooks was served, again, this action was commenced in January of 2013. Christopher Crooks was served at the mortgage property, which is in Bronx, pursuant to 308-2. He was served, the suitable person of suitable age and discretion, her name was Simone Williams. Simone Williams was also served in this action. She was a suitable age of discretion individual, served on behalf of Dorothy Crooks. Dorothy Crooks, in this case, was served at Unit 1 of this multifamily property.
But didn't they live together? Both Mr. Crooks and his sister lived together?
Glad you asked that question, Your Honor. The affidavit submitted by Christopher Crooks' sister states that they did live together. However, there's no evidence that was placed in the record, no documentation or any otherwise that establishes that, in fact, they were living together at the time. Additionally, Mr. Crooks' sister was personally served in this action at Unit 2 in this multifamily property, not Unit 1, which is what Mr. Crooks states, where Mr. Crooks states that he lives. So a very large portion, and I believe the lower court was misled by this, a very large portion of the decision was guided by the affidavits that were submitted by Mr. Crooks' sister. However, Mr. Crooks' sister never established through any admissible evidence that she actually lived in Unit 1 with her brother. She never established that she was at Unit 1 at the time of the purported service, for her to have any personal knowledge of whether Simone Williams, who was the person of suitable agency and discretion, was served on behalf of her brother. And going forward from those allegations, not only did the delivery occur at the property, but then statutorily the mailing then occurred. The affidavit itself was filed with the county clerk, and the time to answer the complaint eventually expired. Fast forward another 8 years, a judgment was entered, and then fast forward 10 years from when the action was commenced. Finally, Mr. Crooks came forward while the eviction action was occurring, the post-foreclosure eviction action was occurring, filing this instant motion. Again, plaintiff appellant will rest at this point and reserve its additional time for rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Stephen Biolsi for the defendant respondent in this foreclosure action. There's a slight misstatement of the facts in that there was delivery to the property. This is
Just a question, why wouldn't it be appropriate to have a traverse hearing? Because it seems to me that, there is a discrepancy, right, with respect to whether service was made on the first floor as opposed to the second floor, because I think the affidavit of service was silent with respect to that.
When the affidavit is silent, it then becomes a nullity, not just a mistake. It doesn't pass on an issue of fact. It, in fact, is just insufficient, as Justice Gonzalez actually held. And that's correct, because we all know this is a multifamily property. How do we know it? Because the mortgage cover sheet even says it's a multifamily. Very tellingly, when 10 years later, my client was actually served in the housing court proceeding, I asked him, well, what happened? Where were you in this matter? He said, well, not only was he never served, he thought he settled it. And those papers, there's no dispute to that he settled the case. And in fact, the proof of that is in the record. So the issue of being served under 308.2, unless there's a doorman, you actually have to serve the unit. Now, if there was a mistake, for example, the process server said that he served apartment 1, and he meant to say apartment 2 or something that maybe could be corrected at a hearing, then I would agree with Your Honor that a hearing might be appropriate. But I still believe that Judge Gonzalez is correct because there's not a statement. And if you look in the—
Well, maybe you'll agree with me on this. So Simone Williams, right, was, she may have been served, January 16th, I think, right? January 16th. Let's see, it was a different day on the first floor that Simone Williams was served. And it just seems to me that what you're trying to do is to say, oh, Miss Williams was served, let's say January 15th, whatever the date was. So that means that she was served on January 30th. And I just don't understand how the two different dates even work. You see where I'm getting at?
Yes, Judge, I do. However, I'm not here to defend the person that we don't even know exists. We don't know if maybe the process server did skip trace search for this phantom person, Miss Williams. Miss Crooks unequivocally says in her affidavit that she doesn't know who that is. Mr. Crooks says he doesn't know who that is. It's just a person that may have had a driver license at one point that would return to that address. Many times process servers just do a skip trace DMV abstract search and just say, well,
So why not a traverse hearing?
Because it doesn't turn on the actual, when you're serving pursuant to 308.2, it's a two-step process. The first part of 308.2 is you must serve somebody at his home. That was never even attempted. And we know that because when we look 10 years later, we see the affidavit of service where he went, the same process server said, I went to Unit 1. I went to Unit 2. He actually did it. And how do we know that? Because he hired an attorney to defend him once he was properly served. Here, there is no issue of fact because the affidavit is incredibly insufficient. It is just a guess. And when you look at the record, you'll notice even the process server wrote The service has been made in order to preserve the notice of pendency. We're continuing to investigate. If the process server truly believed that he served, why would he qualify saying, we're still trying to serve? If you've done your job, you get paid, you're done doing your job. It doesn't make sense. There is no issue of fact that warrants a traverse. Thank you, Your Honors.
You have 1 minute.
Thank you. Your Honors, I want to address the issue of multifamily and service directly on the unit itself, and a misstatement that I believe my adversary may have made. There's case law in the Appellate Division that addresses the issue of whether when service is not necessarily made specifically at the individual unit itself. It could be in the lobby of the multifamily building. It could be upon a doorman at a multifamily building. And that case law.
But Nathan, that doesn't apply here. There's no lobby or doorman. I mean, in this particular case, it's not that kind of part.
Your Honor, I'm not aware of there being a lobby or a doorman, but also no hearing was conducted to see what the structure of this building actually looks like on the inside. There was no fact finding done in the lower court to even address any of those issues. The point that I was merely trying to make by pointing to that case law is that when there's an issue of fact to be tried and to be decided, the answer for the lower court is not to dismiss the case. The answer for the lower court is to have a hearing to dive into that issue and to see whether service was valid or not.
Thank you. Malave versus Kinney. You may proceed.
Good afternoon, Your Honors. May it please the Court, my name is Timothy Gallagher from Shaw, Bomedy, Citron, and Spratt, and I represent the defendants' appellants, the Mount Sinai Hospital and Dr. Paik. Respectfully, Your Honors, defendants' appellants request that the lower court's decision denying summary judgment to Mount Sinai and Dr. Paik should be reversed because defendants' appellants established their prima facie entitlement to summary judgment and plaintiff failed to raise a tribal issue of fact in opposition. And the first reason why plaintiff failed to raise a tribal issue of fact is because the experts that plaintiff submitted in opposition to defendant's summary judgment motion were not qualified to opine on the specific care at issue, which involved nephrology and gastroenterology. Plaintiff's experts were board certified in internal medicine and cardiology, but neither of them professed any familiarity with the standards of care applicable to the specialties at issue, which were nephrology and gastroenterology. In fact, both experts specifically described experience relative to their specialties, but didn't describe any experience that would give them a familiarity with the nephrology or gastroenterology care that's at issue in this case. And because of that, plaintiff's experts weren't able to refute the opinion of defendant's experts who were board certified in those respective specialties of nephrology and gastroenterology that the care and treatment at issue was appropriate and that
Were they qualified to provide opinions on just general medical, issues?
Yes, Your Honor, we don't dispute that they were, that they're qualified as physicians in general, but what I do want to respond to is this notion that I believe plaintiff raised in the respondent's brief that there are sort of these kind of general standards of care applicable across specialties. But that's not something that either of plaintiff's experts opined, that there is a general standard of care with respect to whether a patient should be discharged from the hospital or admitted to the hospital or sent to the emergency room. If that were the case, then perhaps plaintiff's submissions would have been sufficient if they did opine that there was sort of a general standard of care with respect to hospital discharge or admission across specialties. But they didn't do that. Instead, they opined based on their specialties, but didn't opine based on whether or not or identify any experience that would qualify them to opine on whether from a nephrology or gastroenterology standpoint, the decisions that defendants made were inappropriate.
Wasn't this about dehydration, the need of electrolytes, and high blood pressure, or isn't that general?
Well, those were certainly conditions that plaintiff's experts may have been familiar with and certainly claim to be familiar with.
That's also symptoms that the plaintiff was exhibiting.
Correct, Your Honor. Correct, Your Honor. But the issue is whether from a nephrology or gastroenterology standpoint, the decisions that defendants made were appropriate, and we simply don't know from plaintiff submissions whether that would have been the same decision to make so an internist may have made a different decision with respect to discharge or admission.
Let me ask you this question because one was an internist, internal medicine, am I right?
Correct.
So are you saying that that person was not qualified to render an opinion about just the general care of patients as it relates to a hospital setting? Is that what you want us to go with?
Well, not quite, Your Honor. Respectfully, the distinction is that the defendants were looking at their treatment of the plaintiff was from their perspective of their specialty. So from a nephrology standpoint, when they discharge her, they said from a nephrology standpoint, she's clear for discharge.
All right, let's take it. I want to go back. So a person with this background, internal medicine, are you saying to us that this person is not qualified to render an opinion on general standards with respect to the care and treatment of patients in a hospital setting? Talking about admission, talking about discharge. We're not talking about the specialties, but that right there.
Well, respectfully, Your Honor, what I would say is that plaintiff's expert didn't say that there is a general standard of care with respect to admission or discharge. So defendants are saying that at least from the perspective of a nephrologist, this is what the standard of care is, and plaintiffs didn't identify whether or not there's a different standard of care applicable to nephrologists or whether there's a general standard of care applicable across specialties. So Your Honor, respectfully, that would be an issue that the plaintiffs haven't resolved.
Can I ask a question?
Yes, please. Go
You
ahead.
know from your experts, defendants, that inquiry and monitoring of the high blood pressure should have happened and didn't, no?
I'm sorry, from which?
We know from your experts that monitoring of her blood pressure should have happened and did not.
I'm not sure, Your Honor, that we do that.
Okay, bear with me. Because I wrote this out just for you, so bear with me. If it's as you argue, that a doctor is only responsible for treating what falls into their specialty, what is the standard of care for doctors to refer patients to another doctor or a specialist when a symptom that is outside of their specialty develops?
Respectfully, Your Honor, I don't think I can tell you what the standard of care is. I'm not a medical
You just
professional.
said that the nephrologist could only deal with his specialty, correct? She exhibited high blood pressure. So what does he say? That's not my specialty? Go on about your way, go find a blood pressure specialist?
No, I think, Your Honor.
I want to know what you're arguing to us, counsel.
My argument is simply that the decision that there would have been up to another specialist.
Not a nephrologist. So what that her blood pressure's high? That's not my job. Sorry, can't help you.
Well, there are other doctors at the hospital responsible for the discharge decision.
She referred to the other doctor by the nephrologist. Hey, her blood pressure's a little high. Can you check on her?
Well, Your Honor, I would just note that I think that Dr. Kinney, who's also here going to be arguing next.
I got questions for Dr. Kinney. I'm asking you.
Okay, well, I believe that Dr. Kinney was also involved in the discharge decision. So it wasn't just the nephrologist who made that decision. There were other doctors involved in that decision as well. Thank you.
Thank you.
You're welcome.
Good afternoon, Your Honors. I'm Judy Shamitzi from Wilson Elster for Dr. Kinney. I would start, but I feel like there's a question hanging in the
I have
air.
a question for you. Bear with me, it's rather long. The record reflects that at different intervals in the plaintiff's treatment, she was referred to numerous doctors because of new developing symptoms. Can we agree to that?
Yes, Your Honor.
Okay. Once Kinney, am I saying his name correct? Yes. Removed the abscess and found the plaintiff's white blood cell count was high, he referred the plaintiff to an infectious disease specialist, then to a GI, and then to a nephrologist, correct? Are we
Yes,
on
Your
the
Honor.
same page so far?
Yes.
Great. So tell me why, when the patient presented with a sudden and unexplained cardiac symptom of high blood pressure and elevated potassium, he neither referred her for additional workup, testing, or referred her to a cardiologist. What is the standard of care or his duty different? Why is it different from any other onset of her symptoms? And I'm almost done. I ask this relying on your client's deposition, page 696, where he testified that her high blood pressure taken on December 14th was of great concern and that he would want to monitor her.
Just want to clarify one thing about the question before I answer. Your Honor is referring to the post-operative visit with Dr. Keeney, that at that point.
696? I just want to know why he didn't refer her to anyone after the blood pressure. It was so high and he was so concerned that he stated, I would want to monitor it.
But he referred her both at the time of discharge, instructed her for follow-ups, and he knew already when she saw him after her discharge, and he saw her in his office. His office notes reflect that he was aware that she was continuing to follow and that she in fact had an upcoming appointment to follow for.
Counsel, can you show me where in the record, after December 14, Kinney followed up or continued to monitor her blood pressure as he stated he wanted to in his deposition? If you can direct me to where on the record he monitored her subsequent to that, I would appreciate it.
Your Honor, I will find the page number. I asked maybe I can do it in
Okay,
interim,
no
but
problem.
I can absolutely describe the note.
I think
though.
my colleague has a question.
I have another question. Now, is it your contention that a decision whether or not to refer a patient to the emergency room, that does not fall within general medical judgment, but rather, in this exclusive domain, whether it be nephrology, gastroenterology, I don't know how to pronounce it, you do, or surgery? Which one is it? Is it general medical treatment or those specialized areas?
Again, Your Honor, to answer the question, and of course I will, I just really want to focus on the two separate points of where that question comes up with respect to Dr. Keeney, right? So it comes up with respect to the point of discharge. Is she referred for adequate follow-up for the blood pressure and for everything else? And then it comes up when she goes to the post-op appointment with Dr. Keeney, at which point she has appointments lined up with the other specialists, and that is.
She has a follow-up appointment lined up with a GI, but not a cardiologist.
This is true, but at the same time, what she doesn't have is a surgical problem. So what I think
I'm just wondering though, if someone is exhibiting signs of dehydration, low electrolytes, and high blood hypertension, high blood pressure, and those are indicators for which maybe a cardiologist should be consulted, because it could lead to, as we saw here, a heart attack. So where's I think we're having a disconnect as to why no referral was made.
Well, I think the disconnect comes from the fact that she was not the same way when Dr. Keeney saw her, at which point she is relatively well. She is continuing to be able to tolerate intake. She's not, nobody in her, the patient with the least complicated course is never going to have completely normal labs and blood pressures and all of that after everything that has happened. But the question is, when Dr. Keeney sees her in his post-op, it seems like that's where we're focused, in the post-op appointment.
What date is that?
It is, I want to say a week after her discharge, and I will.
I can find that. A week after her discharge, I'll find it.
As the note, which I will absolutely have for you.
Justice Manzanet Daniels, very briefly, because I don't think I got an answer to my question. And my question was, the decision whether or not, and this is general, to refer a patient to the ER. I mean, does that fall within, the realm of general medical judgment, or is it based on a particular specialty, like a special, domain, whether it's gastroenterology, surgery, nephrology? So what is it?
I'm not trying to run from the question, Your Honor. If
I
the-
didn't- I-
if
I
the, if the
didn't say
patient had been, if the patient had been in a condition that required admission to the ER when she sees any physician in any specialty, I believe it is that physician's duty to refer her. The issue is that when she presents to Dr. Keeney post-operatively, she is not in that condition. She is fairly well, she is eating, she is on a course that a surgeon would expect her to be at this stage of her recovery, including
Thank
with
you.
the intervention
I'm not sure
process.
what record you're reading, but thank you. Next.
Good morning, Your Honors. My name is Walter Osuna, for the plaintiff responded, and please the court.
Counsel, could you just start with the issue of the qualifications of the expert?
Of course, yeah, so it's our position that the experts are qualified as noted by the lower court, citing cases like Ocasio-Gray, that the court has the appellate division, the first department has consistently held that it doesn't have to be the same specialty. Here, the issue at question is the symptoms. Can the expert opine as to the treatment as the symptoms experiencing by the patient? In this case, an expert in internal medicine who also has experience as a hospitalist certainly can make opinions as to that. She was in the hospital setting, and part of our allegations, there's two main points that we're saying here. That she shouldn't have been discharged when she did, because she still had abnormal lab values, her potassium was still low, her creatinine was still high, she still had the infection, her acute kidney injury had not resolved, so she shouldn't have been discharged at that point. And that was done by Dr. Kinney. And the second is in terms of, even despite being discharged, when she presented with additional symptomatology like vomiting, diarrhea, the high blood pressure, and epigastric pain by the time she goes to Dr. Pike, these are again symptoms that are general symptoms that can be treated by an expert in internal medicine.
Your
and any other
adversaries seem to argue that these, while she might have been exhibiting general symptoms, they were not related to the surgeries that they were dealing with.
But it has not to be related to the surgery, because even though the history of the gastric bypass is relevant to the history, not to the treatment itself. I can assume that she was assigned to Dr. Kinney because she was a gastric bypass patient, but why she came in was with sepsis and came in with an abscess from a gluteal abscess.
And that was post-surgery, right?
Post-surgery,
That was,
right.
Like September.
The surgery happened in September. The presentation with the gluteal abscess happened in December.
And then the specialist, the plaintiff, specialized knowledge with sepsis, right? The expert.
Our internal medicine
Right.
doctor, part of her patient that she treats, as noted in her affidavit, is treating patients with sepsis. So the symptomatology in question here is appropriate, of course, for a doctor in internal medicine. And also we have the cardiologist as well, because in the underlying papers that were questioning the proximate cause. That's why that is my other point that I want to touch, that is not based on speculation. Their own records, meaning defendant's Mount Sinai records, attributes the cardiac arrest to the electrolyte imbalance. And that's the decision made by the cardiologist working within the system. And it's consistently with the records, even throughout Mount Sinai, that was the reason why, aside from the records from Metropolitan Hospital, who's not even a party in this case.
You continue.
So as I was mentioning, just to reiterate it, that what it seems that my opposing counsel is not taking into consideration that the standard of care is to treat the symptomatology, whether the expert can opine about the symptoms as noted by the lower court.
She's discharged on the 12th of 2017, correct?
2016, December 12, 2016.
She comes back on the 14th to say, I'm not feeling well.
Correct, to Dr. Kinney, correct. And then she's actually.
She comes back on the 16th and says, I'm not feeling well. My
And
blood
with new
pressure
symptoms.
is high. She goes into cardiac arrest that same day.
Correct, and that visit earlier that happened within the hour, she had now epigastric pain. There's a question here in terms of whether she couldn't eat or not drink at all, but just considering the subsequent records, the prior records, when she already noted difficulty eating when she presented on December 14, corroborates that at the time that she presented for Dr. Pike, she was not able to eat or drink because Dr. Pike in the records also noted that she had dysphagia, noted that she had vomiting, and he testified that she had multiple complaints at that point. And he did not properly.
And on the 14th, she was also, in addition to blood pressure, her blood pressure being high, she stated that she was having diarrhea more than 3 times a day.
Correct, and that was also on the 14th. It was consistent. And in terms of the medical records itself, before she was discharged, there's no indication that they were resolved by the time that she was discharged. They were presenting also during the hospitalization that she had diarrhea and that she had vomiting as well.
Thank you.
You have a minute.
Your Honors, I would just like to briefly ask that in the event this court is not persuaded to dismiss the medical malpractice cause of action, defendants would request that at a minimum the lack of informed consent claim as against Mount Sinai Hospital, Dr. Paik, be dismissed. Plaintiff didn't oppose its dismissal in the underlying summary judgment motion or respond to the arguments on appeal. So in effect, plaintiff has effectively conceded they've abandoned that claim. So at a minimum, that claim should be dismissed. But with respect to Dr. Paik, I'd also just like to address an issue with the records. One of the things underlying plaintiff's expert's opinion that Dr. Paik should have sent plaintiff to the hospital was this notion that she couldn't eat at the time of that visit on December 16th. But Dr. Paik actually was asked about this at his deposition and clarified that she actually was able to eat, and in his records actually noted that she was counseled on small meals and eating soft foods, which would support that she was able to eat something at the time.
Counsel G. Okay, mic is now on. Do you want to address the plaintiff's expert internist who had the specialized knowledge of sepsis, and certainly there was, sepsis post-surgery? Do you want to address that?
Well, Your Honor, I'm not sure what specific point you want me to address with respect to that, just whether there was sepsis. The reason why the plaintiff was discharged because her condition was improving as of the time of discharge, and the medical professionals felt that she could be managed as an outpatient.
Thank you.
2227 is the page that I owed to the court, Your Honor, and the date is 12/14 is when she sees Dr. Keeney. And the notes are that she doesn't have the more severe complaints at that time. Dr. Keeney's testimony with respect to the BP is she is seeing other physicians who are in a better position than I, in the grand scheme of things, to deal with that in connection with all of the other things she still has going on with her lab values, but that the blood pressure alone, which is really the only issue I guess we've been talking about, does not warrant her immediate hospitalization. Her blood pressure is 180.
180 over 96 on December 14th?
And I'm not saying that that's normal. I'm saying it doesn't warrant the emergency.
You think?
No, I'm not. I'm saying it doesn't warrant the emergency room. That's all I'm saying. The question is, why didn't he send her to the emergency room? Because she didn't warrant an emergency admission with 180 over 90 and eating. That's what I would just, I'm so sorry.
All right, thank you. One Icon Partners versus Alliance Bernstein. You may proceed.
May I proceed, Your Honor?
Yes.
Good afternoon, Sean Murphy, representing Appellate Alliance Bernstein. As you know, I'm here on an appeal of an order requiring a second deposition of my client, Alliance Bernstein, who's a non-party in a litigation pending in Nevada. As we pointed out in our briefs, the court made 3 errors in requiring a second deposition. I'd like to focus just given the limited time on one of those errors, which is the notice in the subpoena and whether it provided Alliance Bernstein with notice that the recent transactions in Crossgates would be a topic, and did it do so with the statutory requirement of reasonable particularity.
On that question, in the subpoena, one of the points was for communications with Putnam or Trimont concerning the Putnam letter of January 2022.
Yep.
Does that letter make reference to the Crossgates Mall?
So that letter has one reference to Crossgates, and it refers to something very specific. It's dated December of 2022, which was a year and a half before.
It makes reference to.
It does make reference to it.
And then the next one references the CR2 trust. I think there's a couple of references in the subpoena to the CR2 trust. And is the CR2 trust the holder of?
So CR2 is an index of Crossgate's securities, if it's an index. So CMBX6 is the broad index up here. Then there are various trusts beneath it, including CR2 and CR4. And then beneath one of those, CR2 is Crossgate's, among with others, just as the S&P 500 index would include 500 securities.
So you're saying that's too vague to?
Well, the problem is my client invested in CR2 and CMBX6. So when a subpoena topic says, tell me about your investments in CR6, we provided information and said we invested X amount of dollars on this date in CR6, or CMBX6. We invested in CR2. We provided dates, the times. If you wanted information about investments that just happened, 2 days before the subpoena was issued about something that had nothing to do with the Putnam letter, you could have easily said, I want to talk about your investments in Crossgates. But because...
Let's go back. The subpoena annexed the complaint in the Nevada action.
Correct.
All right. And then that complaint, I think it references the Crossgates Mall, as an example of the attempts to apply pressure as it related to CR2, right?
I'll accept that. I mean, it's slightly...
I'm paraphrasing.
Yes,
okay?
no, I
I'm
accept your paraphrasing.
Yeah. So, it just seems to me, in my paraphrase, that, if the complaint mentions Crossgates Mall, goes through all of the alleged improper attempts, mentions CR2, why wouldn't that be sufficient notice?
Well, and my client actually answered questions about that letter and Crossgates and the events in 2022 that happened. We had no objection to that, because if you look at that letter, which mentions Crossgates once, after a 140-page complaint, it attaches a 2-page letter in small font that mentions it like this. It's there. I'm clearly not disputing it, as is CR2, but it wasn't a topic.
And all we really need is some sort of that it may enumerate. It has to be material and necessary, reasonable particularity. If you're looking at Nevada law, why is it not enough?
With respect, Your Honor, you're bleeding into relevance, which I'm happy to talk about too, but I think where we started was it a topic? And it may be mentioned once in a 140-page complaint.
Because it was very detailed. That complaint was very, very detailed.
As were the topics in the subpoena. But Crossgates, as the judge found, mentions Crossgates in the subpoena, which it clearly does not. If I gave that subpoena to someone that didn't have the benefit of all of the briefing and 600 pages of reference, and I gave it to your interns and visitors today here, and I gave them that, which has...
But that's not who you're giving it to.
Well, if you're
That's
giving
not
it...
who's receiving it.
Well, if you're giving it to anybody who just said, tell me, is Crossgates mentioned in this subpoena? Does it talk about Crossgates? And I gave them a yes or no. They'd say no. Is it mentioned with reasonable particularity? There's no way anybody would say no. I get it. Could you talk about the Putnam letter?
Well,
yes, but your recent transactions that just happened, when you're saying, tell me about investment A, B, and C, but not D, they now want to talk about our communications with the winning bidder of that, which
All right.
they list.
You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Nice to see you again. Michael Hannon from Palace Partners, on behalf here of the petitioner respondent Icon Partners. Justice Saunders below, she held argument, she considered evidence, and she issued a reasoned and thoughtful decision that we're entitled to an additional 2-hour deposition of Alliance Bernstein because they refused to answer certain questions. This court may substitute its discretion for Justice Saunders on discovery-related matters, but that's a power it invokes only rarely and reluctantly. I'll address notice because regardless of the standard of review, the trial court was absolutely correct. It is the respondent's, the appellant respondent's burden here to demonstrate a lack of notice. As Your Honor mentioned, Crossgates was featured in the complaint attached to the deposition subpoena, including in Exhibit A, which was the Putnam letter. As Your Honor noticed, the Putnam letter was an explicit topic in the notice. The idea that Crossgates was an aside or an allusion in Exhibit A in the Putnam letter is simply false. The Putnam letter was about cross-gates. There's no other way to describe it or think about it. The CR2 trust, I believe my colleague said it was an index. It's not an index, it's a trust that held cross-gates. And the CR2 trust was used as a proxy in our subpoena because it was sufficiently broad to capture cross-gates, but not overly broad to capture other elements of the CMBX6 index. In addition to topic 12, which Your Honor noticed, which included the Putnam letter, there were 6 other topics in the subpoena that identified the CR2 trust. Most notably, and I think this was persuasive to the judge below, in communications in advance of the deposition, we specifically identified cross-gates for Alliance Bernstein's counsel as one of the 6 search terms to apply to the documents to be produced in advance of the deposition. That's at 746 of the record. We gave them 6 search terms. One of them was the name of the defendant, 3 of them were the name of the property in the Nevada action, and then 1 was Putnam, who wrote the cross-gates letter. The 6th was cross-gates. I think the reality of what happened here, which the lower court clearly recognized, is that Alliance Bernstein knew we intended to inquire about cross-gates, chose not to address that fairly and openly before the deposition, and then stonewalled at the deposition in the hope that we wouldn't follow up with this petition, which was obviously burdensome. We did seek sanctions in connection with the petition. The judge denied that. But ultimately, there was no basis for refusing to answer the questions at the deposition, and we stand on our papers. Thank you, Your Honor.
Counsel, you have a minute.
Thank you, Your Honor. Just going back to the complaint and the Putnam letter, the Putnam letter attached to it. I mean, as I said, it does mention it, but a complaint, which is a long complaint, can include many things. It doesn't mean the deposition is going to cover it when you get what is the equivalent of a 30B6 Nevada subpoena that has to specifically list the topics of inquiry. The complaint could talk about 100 other things. The topics have to be described with reasonable particularity. It does not answer that question. You can't circumvent it simply by saying the complaint, which was attached, is part of one of the topics. It wasn't one of the topics. In terms of the communications that counsel mentioned beforehand, as we pointed out in our brief, that was about a document subpoena, a separate subpoena that was served long before that related to a time period before the Alliance transactions and cross-gates even took place. And it was a limiting search term that didn't mean anything to me at the time. Thank you, Your Honor.
Thank you. Beth Page, Federal Credit Union versus BR 52. You may proceed.
May it please the court, Christopher Gorman, Rosenberg and Estes PC for the appellant. I'd like to begin with the lower court's conclusion that paragraph 38 of the complaint was sufficient for the plaintiff to plead its standing in this case. That allegation of the complaint makes no reference to an allonge. The only thing it references is possession of the note. What this court's case law, and the case law of the Appellate Division 2nd Department as well, has made very clear is that where there is an allonge, there needs to be something to show that the allonge is firmly affixed to the note. All this complaint says, in bald and conclusory terms, is that the allonge is firmly affixed. And I would submit to this court that that is the sort of legal conclusion that on a motion to dismiss, a CPLR 3211 motion to dismiss, is accorded no weight. The same way as if you just put back in the terms of a statute. That's effectively what you are doing here. You are effectively putting into a legal pleading the terms of the UCC, which the UCC requires. But that alone is not sufficient to establish, even at the pleading stage, the plaintiff's standing. I also want to address the assignment of mortgage, which the Supreme Court mentioned in the appealed order. In that assignment of mortgage, there is no assignment of the operative loan documents that are the subject of this foreclosure case. There's a consolidated note, there's a consolidated mortgage. The assignment of mortgage that is included in the record does not include an assignment of those loan documents.
What did the consolidated note include? What did the consolidated note include?
The consolidated note included all of the prior loans that had been extended, which were then rolled up into the consolidation. I want to move on to the acceleration notice argument.
And how does the 2018 consolidated note not establish standing?
How does it not establish standing? Because the notes leading up to that note, there's a series of allonges included in the record which are attached to the notes which get rolled up into that note, and it is those allonges which form the basis for our motion to dismiss. I didn't draft the complaint, right? The way the complaint is drafted, it lays out in very, very painstaking detail that whole series of prior loans. I see that my time is up.
I'll let you complete your thought.
Sure. The way that the complaint is pled is it lays out the entire loan history. And then what the consolidated note says is that it is rolling up into it all of those prior notes. But our point is that the allonges that are included with those prior notes, there is no allegation as to how those allonges are purportedly firmly affixed to those notes.
Thank you. You may proceed.
Good afternoon, Your Honors. Stephanie Coughlin for the respondent, Terracotta 9, LLC. We respectfully ask the court to affirm all aspects of the August 27, 2024 order. So this is a very straightforward foreclosure action involving a $37 million loan secured by a Manhattan property on 52nd Street. The borrower received the loan for $37 million and admitted all of its obligations under the loan. It admitted the notes were owned and held by the original lender, Beth Page, and it admitted that there were no defenses. It stopped making payments on the loan in November 2023, and it now seeks to avoid repayment through a series of procedural arguments.
Counsel, a question for you. Where in the consolidated mortgage did it even indicate that, plaintiff was required to send a default notice? I don't recall seeing that.
Sure, so that's in section, I think it's 2.1, Roman numeral 1, page 119 of the record. And there it says that except for an event of default under a series of subcategories, including the default that we're alleging here, the mortgagee will provide the mortgagor with notice of default. So it specifically excludes the scenario that we're dealing with in this case. But I'd like to go back to opposing counsel's argument regarding standing. There are only 3 notes at issue here. It's the restated note, it's the second lien note, and the multiple disbursement note, all of which originated with and executed by the borrower and were given to Beth Page. There were no allonges to the 3 operative notes. The allonges only relate to the 2015 notes, which were then all consolidated in the restated note. So I think there is a fundamental misunderstanding with respect.
Counsel seems to think that in order for that 2018 note to be valid, you'd have to now include all of the things going back to 2015.
Right. All of those records were included in the complaint more to provide context and to explain how we got to the restated note. But the restated note itself was executed by the borrower and given directly to Beth Page. So all of those notes are important context to explain how we got to the restated note, but the allonges actually are irrelevant for purposes of standing here today. And with that, I rest.
You specifically allege in the complaint you're the owner and the holder of the note.
Exactly, Your Honor. We allege multiple.
The 2018 note.
Correct, which are the 3 notes that are being foreclosed upon here today. So those are on pages 24 of the record, 27 of the record, and 31. And the Supreme Court correctly held that alone is sufficient to defeat the motion to dismiss.
Thank you so much. Have a good day, both of you. People versus Quintin Rodriguez. You may proceed when you're ready.
Good afternoon. On behalf of Quintin Rodriguez, Phoenix Rice Johnson, there is no dispute that after receiving the jury's 9th note, the court did not show the note to counsel, did not read the note verbatim into the record. Instead, the court summarized the note, making it sound as though the jury was requesting a specific exhibit, when in fact the note was more ambiguous than that. And then, without asking for any input from counsel, the court sent the jury some evidence. This was a clear...
Counsel, wasn't the 9th note about the jury wanting to see an exhibit?
The jury requested to see the evidence containing the drugs. And here...
Now, there was only one exhibit that contained the drugs, right? Just one.
There was one exhibit with physical drugs. However, containing here...
And they wanted to see the drugs, which was in one exhibit, right?
The note is ambiguous because here where Mr. Rodriguez was charged with 3 separate counts of criminal possession of a controlled substance, so much of the evidence in this case had to do with the drugs. They could have been requesting to see the photographs where the drugs were found. They could have been requesting testimony.
Had there been other jury notes?
Yes, there had been other jury notes.
And other jury notes were specific to those items that you're listing now, right? And so when we get to jury note number 9, and the jury note reads to see the evidence containing the drugs, at that point, why isn't it just a ministerial act of sending that particular evidence back to the jury? How does that even fall within ORAMA?
So this court has made clear that where a note, even a note requesting evidence, is not is ambiguous, then the ORAMA procedure is invoked. So you mentioned...
But I think that the case law to this court is that where it is unambiguous and where it is a ministerial act and where it is just something as simple as submitting evidence to the jury, then it's outside the parameters of ORAMA, and that's not necessary. And I think that our case law, Durham, McNeil, I think it is, would lean towards that.
Well, here the note was not purely an unambiguous ministerial note. You mentioned that there were previous requests for physical evidence, and that is true. In note 6, for example, they requested to see the evidence with the bag of drugs, and that was a precise physical descriptor of an exhibit, whereas here the evidence containing the drugs may have been referring to any number of items. It's also worth noting that...
Was there any... Was there anything on the record, because this was right after the jury had exited the courtroom, like it's a whole series of proceedings that's going on. Is it your position that defense counsel was not in the courtroom at that time?
Not to my... No, Your Honor, I'm not arguing that.
Because, in fact, before the exhibit even went into the jury, I believe the court did advise both parties, and there was no objection by defense counsel. So defense counsel was aware of the court's decision to send in that exhibit, Exhibit 9, and there was no objection, I believe.
An objection wasn't necessary here because where a note, the underlying note was ambiguous.
No, that's not my question. My question is that prior to the court's decision, the court did advise the parties of the intent to send Exhibit 9. And there was no objection placed on the record. That's my question, which is usually a yes or no.
May I read the precise language?
Please.
I believe the court says, the jury's requesting to see the evidence, namely the drugs, so we're going to send that back to the court officer's supervision. So even what the
With
court...
no objection, right? Was there an objection placed?
No, there was no objection.
Defense counsel say, I want to see the note, Judge?
No, but that wasn't necessary here because counsel had no notice of what the underlying note said. And if counsel had, perhaps counsel would have said, wait a second, that could be referring to any number of things. Contain also means involve, and here so much of the evidence involved the drugs. But counsel wasn't put on notice that that's what the underlying note said, which is precisely why when there is an ORAMA failing, that is a mode of proceedings error that does not require preservation.
But if we were to find that this was a ministerial issue, then you would agree that it's outside of ORAMA and
Where it is a purely unambiguous ministerial request, it is outside of the realm of ORAMA, but the facts here do not support that. Thank you.
Thank you.
May it please the court, Nayeon Chung for the people. Starting with the jury note issue, the jury's note asking to see the evidence containing the drugs was an unambiguous request to review People's Exhibit 10, the only exhibit in evidence that literally contained the drugs. As such, the request—
But why wouldn't the court just say, show the note to counsel and then read it verbatim into the record? Why isn't that necessary?
So the court did either show the note or read it verbatim for all of the substantive notes. For this one, the request was ministerial, and there was no need for the court to do anything other than what it did. It said it would send the drugs back, and as your honors mentioned, defense counsel did have the opportunity then to object. I think the context is important here. The earlier 6th note, the jury asked for the evidence with the bags of drugs, and the court did show that note to both parties. There was no objection. The court then sent the drugs to the jury. And then in the subsequent note sent that same day, when the jury asked to see the evidence containing the drugs, the court reasonably understood it was asking for the same evidence again and properly responded by sending it back to the jury. And the jury was perfectly capable of specifying when it wanted to see evidence other than the drugs, such as the photo evidence, the same 6th note. They wanted to see not just the evidence with the bags of drugs, but also the photo evidence, and specified very particular portions of Detective Villalona's testimony.
Counsel, did the jury send a note subsequent to that saying, well, that's not what we wanted something else?
No, there's nothing in the record that would support that. Moving on to the suppression issue quickly, the hearing court properly denied defendant's motion to suppress his statement. Detective Villalona's question to defendant asking if he was comfortable leaving in the attire he was in was reasonably related to police administrative concerns, namely providing for defendant's physical needs and ensuring he was dressed before transporting him to the precinct. The temperature that morning was 46 degrees Fahrenheit. Defendant was wearing only a tank top, shorts, and socks. The question was thus objectively reasonable given the cold weather that day and defendant's state of dress. As for the weight of the evidence, overwhelming evidence established that defendant constructively possessed the crack cocaine in the bedroom, and the jury's verdict comported with the weight of that evidence. First, defendant's close proximity to the cocaine in open view in the enclosed bedroom was on its own direct evidence that he exercised dominion and control over the cocaine. And moreover, evidence that he in fact resided in the apartment further evinced his possession of the drugs. When the detective asked for his home address, defendant admitted he lived at that very apartment. And before leaving for the precinct, he asked the detective to retrieve very specific items of clothing from the bedroom that fit him. And when the detective went to retrieve these items, he saw other clothes and shoes that appeared to be the same size. So the inference was that he had his personal possessions in his personal space and that this was defendant's bedroom. So the people's proof conclusively established that he had constructive possession of the drugs. If there are no further questions, we ask that you affirm. Thank you.
Thank you. I'll give you her leftover time.
With respect to what my colleague on the other side of the aisle just mentioned, the fact that the jury had requested the physical drugs in an earlier note just hours prior that day actually supports our argument, because it's not clear why they would change their language and start referring to it in a different way instead of asking again for the bags of
I'll
drugs.
ask you the same question. Did the jury then follow up with another note saying, no, that's not what we wanted. We actually wanted to see whatever else?
No, but that's not required under the ORAMA standard. It's also not clear why they would be
Then
asking.
wouldn't that would kind of point to whether or not the note was ambiguous or not, or whether or not the court misinterpreted the note, wouldn't it?
Well, it is upon the court and the parties to have a dialogue around ambiguous notes so that it can be, hammered out. What exactly are they asking for? The onus shouldn't be put on the jury to say, I think they may have misinterpreted this. I'd like to briefly address the Miranda point here, where everything in the case rests on proving that the suspect had physical control over the premises, a question that was likely to elicit information linking the individual to physical items in the apartment was clearly going to be used as evidence to prove constructive
When that
possession.
question was asked to the defendant, there wasn't any reference to, do you want me to get the clothes out of the closet in the room where we found you, right? It was just, are you okay to go out like that?
Are you okay leaving the apartment in your current attire? And I think the entire factual story here is crucial, and I'll try to keep it short. But
Yeah, since your red light is on already.
I'll briefly summarize.
Okay.
Going into the search warrant, John Saunders and John Saunders' alone name was the individual that they were searching for. After arresting Mr. Rodriguez, they didn't ask him anything about his attire. It was only after completing a comprehensive search of the apartment, finding no lease with his name on it, no keys on his body linking him to the apartment, no mail with his name on it, did they realize we need to find some way to link him to this apartment. And Detective Villalona, who was the head investigator in this case, was well aware of that. In fact, he testified that part of his responsibilities in this case was determining who owned the physical drugs and who was a resident of the apartment. Given all of that context here, that question was clearly investigatory, and under these narrow facts, it should have been Mirandized first.
Thank you.
Thank you very much.
Lotrian versus 3M Company. Yep, just pull a chair up, that's fine. You may proceed, ma'am.
Good afternoon, Your Honors. May it please the Court. Monique Weiner on behalf of EIDP Incorporated, who is one of the appellants in this matter. This is a toxic tort case, and Parker versus Mobil Oil Corporation from the Court of Appeals is the leading case on causation issues in toxic tort cases. So Parker gave us really good guidance on how to assess the issues here. There are 3 requirements to prove causation: the level of exposure to the toxin, general causation, and then specific causation. With respect to my arguments here, I would like to focus just to the general causation issue because that is dispositive of everything. And I would respectfully submit that the plaintiff's arguments focus on the level of exposure, and rightfully so, because the Nemeth case and other cases that are toxic tort exposure cases do talk about the necessity of getting a level of exposure. But with all due respect, I think the lower court conflated that prong of the causation analysis of looking at the levels of exposure versus general causation. What the Parker case showed in very clear words to us here in this case, because what is claimed by the plaintiff is that benzene, and particular to my client DuPont, benzene and DuPont paints caused his myelodysplastic syndrome. So the causation issue is there enough sufficient evidence from the expert side to show that the ingredients in paint, which are not benzene, that is undisputed in this case, the ingredients in the paint are toluene, xylene, naphthas, other materials that can be contaminated with benzene as part of the petroleum distillation process, but they are not benzene in and of themselves. And Parker is so instructive on this particular issue because in Parker, the claim was that gasoline, which also contains benzene, anecdotally, not at the same level as paint. Paint is a lot less containing in terms of benzene than gasoline. And how the Court of Appeals decided Parker is they said there was not specific evidence that gasoline, not benzene, but gasoline was capable of causing the disease at issue. And so that was dispositive in Parker. That is exactly the same issue that we argued to the lower court. And the lower court properly found that DuPont had met its prima facie burden of proof that there is no general causation, again, between the ingredients in DuPont's paint, the toluene, xylene, naphthas, hexane, and myelodysplastic syndrome. And then in examining the plaintiff's proof, where the lower court was confused, I believe, was it started to look at studies cited by the plaintiff that really went to that issue of levels of exposure. And there are some studies, particularly by Dr. Kopstein, that are cited by the plaintiff that talk about the fact that because there is benzene contamination in some of these constituents, they need to be listed on MSDS sheets, meaning material safety data sheets. And so he's published literature talking about there is a reason to give warnings and to be protective of these kind of constituents, but that is not the same as causation. And so that's why I'm advocating to this court that a reversal of the lower court's denial of DuPont's summary judgment is appropriate because there is not sufficient general causation evidence here to say that the lower court got this issue right. I would like to just say as an issue that I expect the plaintiff to raise, this is not a Fry issue. We are not saying here that the plaintiff's experts haven't done the appropriate methodology. This is an issue of admissibility of evidence. If there is not sufficient evidence to show the materials in our paint caused the disease at issue, that is not relevant evidence. And the controlling case law says that kind of information is for the court to decide as a matter of law. And so that's why we are here asking for this court to reverse the lower court's decision and find that DuPont's motion for summary judgment was properly supported. I'll reserve my time for reply.
Thank you.
May it please the court, my name is Michael Senna, and I'm here for Appellant Rust-Oleum Corporation. I'm going to only focus on one of the issues. The rest I'll rely on my brief. And the point that I want to make here is that the court below erred in denying our summary judgment motion because after 4 years of discovery, there's no evidence that the plaintiff was exposed to benzene in Rust-Oleum's auto primer, the product at issue that the plaintiff claims he used when he worked at Camera Auto Body painting the undercoating of cars. Despite the arguments from the other side, the issue is not whether auto primer contains solvents such as toluene and xylene. The issue is whether or not those solvents were contaminated with benzene.
But between 1978 and 1993, didn't your environmental scientists testify that Rust-Oleum didn't test the primer for benzene?
Rust-Oleum did not test the solvents for benzene, and the evidence is they didn't have the sophistication, the testing, the knowledge. Even plaintiff acknowledged that the sophistication was in the solvent manufacturers. Rust-Oleum relied on the information given to them by the solvent manufacturers as to what was in those the solvents. And based on that information, they put that information on the MSDS sheets. But they did not test their product. But this case was prosecuted on the theory that the plaintiff brought in the solvent manufacturers into the case and who supposedly supplied the solvents to Rust-Oleum and others. But that theory has been rejected by the lower court in an opinion that's not appealed in this case. The lower court dismissed the solvent companies and saying that there was no evidence that any of the products that they made, whether contaminated by benzene or not, was found in the finished products, including my client's Rust-Oleum. And that's in the record, page 30, where the court said it's entirely speculative to conclude that the solvent suppliers were actually incorporated into the manufacturing's finished products, citing this court's decision in SOCIA. And the reason why that's important is because even plaintiff has acknowledged that not all solvents are contaminated by benzene. And they prosecuted this case based on that theory, unappealed denial of summary judgment. And I think it's important to note, Your Honors, that in the plaintiff's 72-page opposing brief, quite very well written, Other than a passing reference in footnotes, there is no discussion of the impact of the lower court's decision on this case. And I submit, and it's in our reply, that's law of the case in this matter. We understand that it's not binding on this court, but this court has held, unless it's some extraordinary circumstances, that lower court decision should be applied here. And that's what we have here. And so I submit the dismissal of the solvent manufacturers means that they can't trace any of those solvents, whether contaminated by benzene or not, into a Rust-Oleum finished product. Unless the court has any questions, I think
You'll have
my
2
time
minutes
is
on
up.
rebuttal.
Thank you.
Good afternoon, Your Honors. Josh Snyder on behalf of ZEP for the appellant. My issue is a little bit different than my colleagues. My issue relates to the lower court's denial of my client's motion for summary judgment as it relates to plaintiff's manufacturing defect claim. Plaintiff's claim against my client relates to a product called ZEP PLS. ZEP PLS it's a penetrating lubricant used by mechanics to help them remove rusted nuts and bolts that are stuck. It was sold in an aerosol can. Plaintiff's claim is that every single can of ZEP PLS sold for 8 years, including those used by Mr. Lotrian, as well as every other can manufactured during that period, was defective because those cans were made as designed. It is not a manufacturing defect claim. The plaintiff's theory is that every single can of ZEP PLS was defective because of the ingredients that were used in ZEP PLS. We cite numerous cases in New York that distinguish between a design defect, which is the entire product line is defective, which is what plaintiffs allege, although they've abandoned the design defect claim, versus a manufacturing defect claim, which is when there are specific units, typically one, but maybe a few, right, where those units deviate from all other products in the line because they weren't made as designed. Plaintiff's claim against my client is a textbook design defect claim. It is not a manufacturing defect claim. They have abandoned their design defect claim rather than try and establish the requirements under New York law, and instead seek to prove it as a manufacturing defect claim, kind of to circumvent those requirements. Again, we cite numerous cases up and down the New York state courts, as well as, I know not binding on this court, but I think 16 federal court cases applying New York, dismissing plaintiffs' manufacturing defect claims when they claim the entire product line is defective. Some examples I liked were the Tide Pod case, where every Tide Pod stains the clothes. Design defect, not a manufacturing defect. Every can of Pam we use for our cooking spray, defective. That's a design defect, not an individual. Again, it's really, I think I would point to Judge Jason's dissenting opinion, which the majority doesn't disagree with this point, but I think he says it best in the Capriati versus Chrysler Corp. And he wrote, "A real distinction exists both in law and fact between manufacturing defects and design defects. Manufacturing defects, by definition, are imperfections that inevitably occur in typically small percentages of products of a given design," end quote. Again, plaintiff's theory against my client is that for 8 years, every single can of this product was defective, had the same defect, precisely because it was made as designed. For that, I'd ask you guys this court reverse the lower court. Thank you.
Thank you. Okay, now we hear from the plaintiff here.
Good afternoon. May it please the court. Susanna Chester for Mr. and Mrs. Lotrian. Taking the arguments in the order in which counsel presented them, first of all, the correct frame for the general causation issue is from Parker, and it is this. In Parker, the question was the relationship, if any, between exposure to gasoline containing benzene as a component.
So, counsel, let's assume that DuPont, establishes prima facie entitlement to summary judgment. How did you raise an issue of fact with respect to general and specific causation?
An issue of fact was raised with respect to general and specific causation through the mathematical modeling performed by Mr. Medina, which included, particular to general causation, the references to the studies from that discrete time frame that showed that the solvents contained within DuPont's paints and primers were contaminated with benzene. That's in the record at 402 to 403.
Was there anything specific as to the amounts of the benzene?
Yes, Your Honor. The information that is specific to the amounts, again, is drawn from the scientific literature analyzing the benzene content of the solvents in DuPont's paints and primers during the relevant time frame, and that is at 1401 to 1403. In addition, it is also, that's in Mr. Medina's affidavit. In addition, it is also borne out when we look at the Carmine auto body studies, which were performed by DuPont on its paints and primers and demonstrated that benzene exposure occurred during the course of those tests. General and specific causation are inextricably linked here.
Just want to go back to Mr. Medina.
Yes, sir.
Because I believe there was an assumption made that all of the products, like 0.1%, right?
Yes.
So my question is, what was that assumption based on? Because it just seems that there was just an assumption and really no indication of how we came up with that number. What was that based on?
That number was, again, drawn from the JJOC and Levin studies, that those are listed and the benzene content is discussed at the joint appendix at 1401 to 1403, where he lists out the studies showing the benzene content of the underlying solvents that are contained within DuPont's products.
But didn't DuPont stop doing the study by a certain time? So does the Medina report then just assume that there's no change in how DuPont made its product, and that was the same amount of benzene in the paint or their product that's at issue?
No, Your Honor, it does not. Specifically, the studies that you will see itemized in the table on those pages of the joint appendix cover the time frame from 1978 to 1993. Conversely, just to compare it to Dr. Kerzik's affidavit, which was submitted by DuPont, all of the studies, with a few exceptions, all of the quotations he has included post-date 1995, after the relevant time frame. In addition, Your Honor, if you were speaking to the Carmine Auto Buddy study, again, performed by DuPont, that specifically went to DuPont's products. It was conducted in the late 1970s, and it did demonstrate a release of benzene from the use of DuPont's products specifically, which goes to essentially corroborate the scientific findings within the studies itemized in Mr. Medina's affidavit, showing that those solvents are contaminated with benzene during that time frame. This is not a situation where DuPont was only using, just for instance, nitration-grade toluene. That is not the evidence before this court. What the evidence before this court is that DuPont is during the time frame from 1978 to 1993, when Mr. Lotrian was working at the auto body shop, that the solvents were simply not refined to that level, that 0.1% level.
And then how did they quantify it in terms of exposure to him specifically?
Specifically for him, what Mr. Medina did was, with respect to the DuPont primers and paints, he utilized a site conceptual model approved by the American Industrial Hygiene Association. He input the Carmine auto body study results, so DuPont's own studies results on benzene exposure, and utilized that model with Mr. Lotrian's exposure information, in other words, hours worked, extent of his exposure to DuPont products, all of that which is contained in the joint appendix at 3183 to 84. With regard to the other products, so DuPont Prepsol, Rust-Oleum, and ZEP, he used what's called a two-zone conceptual model. It had to be different because the data set on the amount of benzene exposure is different. And using that, that's where he came up with the other exposure levels to benzene from the use of these products. Based upon that, that is how looking at that specific mathematical calculation, which has been expressly improved in Parker and Nemeth, that is how Mr. Medina came up with a quantitative, not qualitative, but quantitative number on the approximate amount of benzene that Mr. Lotrian was exposed to as a result of his use of the defendant's products in this case. And then in turn, Dr. Harrison used those calculations to compare them to the scientific literature. A point on that, Your Honors, because I appreciate that this is important. If Your Honors look to the joint appendix at 3326 to 3327 in response to Your Honor's question particularly, Your Honor will see that Dr. Harrison has cited a study that is the 1995 Sandler study. And in that, the publication in the American Journal of Epidemiology shows it's entitled Exposure to Chemicals and the Risk of Myelodysplastic Syndrome, and it found an increased incidence of MDS. This is not from raw benzene exposure, but from mineral spirits, petroleum distillates, pure aromatic, and gasoline kerosene. All of those were elevated increased risks, elevated odd ratios. Those are not raw benzene. Those are the exact type of solvents that were contained in DuPont's products. And they are a mixture. DuPont put multiple different types of solvents into its different paint products. That is precisely what was contemplated by Nemeth and by Parker doing a quantitative assessment, and it creates a material and triable issue of fact. Regarding, again, this goes to Your Honor's questions regarding the amount of benzene contained within these products. This is as to Rust-Oleum's contention that there is no evidence regarding benzene in the products. Again, Mr. Medina went and looked at the scientific literature that examines what level of benzene contamination is in the solvents that are in these products. I'll stop there.
You can finish your statement, please.
Thank you. In the solvents in these products at that time. And again, if you look at Kopstein, Peckham, that's at 2429 to 46 of the joint appendix, you will see that. Simply regarding ZEP, a manufacturing defect and a design defect are not mutually exclusive.
Thank you. Okay, you reserved 1 minute.
I thought I had done two, but I will take one if that's what I have.
Go ahead.
Okay,
I'm
sure.
not gonna.
With respect to Justice Kennedy's question as to how did the plaintiff create a triable issue of fact after DuPont established the prima facie case that the ingredients in DuPont's paint do not cause myelodysplastic syndrome. The answer that you received was that as to the general causation issue, the industrial hygienist did mathematical modeling. And I wrote that down because I think that's important when you compare it to what the Nemeth Court said, the Court of Appeals decision in the Nemeth case that was specifically looking at what was the information regarding the exposures. And what the court said is that as we cautioned in Parker, standards promulgated by regulatory agencies as protective measures are inadequate to demonstrate legal causation. And so that's why I started my argument with the three components of Parker, that there is levels of exposure that you have to show for causation, general causation and specific, and if you don't have all three, you haven't met the standard. Just because her argument says they met the first one doesn't mean they've met the second one. Thank you for your time.
Thank you. And you gentlemen reserve 2 minutes each.
Thank you, Your Honor. Just like in plaintiff's brief, in their oral argument, they totally ignore and never address the issue of law in the case. They never address the issue that the court that has dismissed the solvent manufacturers, that they can't trace any product, any contaminated benzene to a Rust-Oleum primer. Counsel makes reference to information that Mr. Medina set forth, their expert, in his expert disclosure. Even in his expert disclosure, he assumed that Rust-Oleum paints contained benzene based on DuPont's information. In other words, he assumes that DuPont and Rust-Oleum are the same. They're not the same. They're two different products.
I'm glad you brought that up, I'm glad you brought that up because I believe there's a particular page in the Medina report that refers to a study involving DuPont paint and not your client as it relates to why it's been a long day, so you just have to forgive me. But as to establishing, both the general and the specific causation. They focus on that page. I think it was 1401 of the appendix, but it's DuPont paint, and it's not your client.
Correct, Your Honor, absolutely correct. And the last thing I want to mention is, just so they understand, we're talking about one paint. Rust-Oleum's paint is an admixture. It's a combination of a lot of different things. And the safety of the finished paint is the same as the constituent elements because there's no chemical reaction. So when Rust-Oleum prepares its safety information, it relies on the information given to them by particularly the solvent manufacturers and others. And that's how they prepare their MSDS and their label. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. I promise I will be very brief and probably use a fraction of my 2 minutes. I would just note that my client had two kind of separate issues for appeal. The first one I addressed, the second one, for the sake of time, I didn't mention. I would just note it here. In the briefs, we addressed it. My client, Zepp Inc., the appropriate party that should have been sued for the Zepp PLS product is its subsidiary, Acuity Specialty Products. We've addressed it in the brief. It's late in the afternoon, so I'll answer any questions your honors have, but I just wanted to note I wasn't ignoring that issue, just focusing on a different one. And with that, I'd rest on the briefs.
Thank you.
Thank you.
Thank you all. Last but not least, Cardenas versus New York City Housing Authority. You may proceed.
Thank you. Good afternoon. My name is Stuart Diamond. I'm here for the plaintiff appellant, Ms. Cardenas. Please excuse my voice. It's undisputed that Ms. Cardenas's inability to see the motorized vehicle on the sidewalk was a cause of the accident. She testified that she did look to her left and that the plank of the sidewalk shed blocked her view to her left. Clearly, it's also true that the actions of the operator of the vehicle was also a cause of the accident. But it was not the sole cause of the accident. The issue is whether it was the sole proximate cause of the accident. We cited this court's case law stating that proximate causation is almost invariably a factual issue for a jury to decide, and that there can be more than one proximate cause of an accident. And finally, that a court should decide the issue of proximate cause only if that's the only conclusion that can be drawn from the established facts. We cited two cases, both involving similar facts, where the claim was a person who was struck by a motorized vehicle, and their claim against the defendant, the relevant defendant, was that she could not see the vehicle because a fixed object blocked her view. Those are the Curtis and Sherez cases. Respondents have cited in a number of cases. Only one of them really addresses the issue of a similar factual pattern, where the plaintiff was claiming that he or she didn't see the motorized vehicle because of an object blocking a view. That was the Murray case. If you read the Murray case, I'm sure you have, or just specifically the paragraph that we cited in our brief, this court said that it was not a question of proximate causation because it was not a question of causation. This court said in so many words that the hedges that were the subject of the claim, based on the evidence, did not cause the accident. That's not our situation. There is no question about causation. It's a question of proximate causation. So in the Murray case, this court never really even addressed proximate causation because it ruled, as a matter of fact, that the hedges were not a cause of the accident. They do cite other cases. None of them involve the same fact pattern we have here. Those are cases that fairly fit under the category as they label it, and as this court has said, furnishing the conditions for, and merely furnishing the conditions for an accident. An accident happened in front by a car wash or by a parking area. That's not enough. Just because you happen to have a car wash there or a parking area, that's not proximate causation. That's not the claim in this case. We also cited the case law that because they raised the issue about compliance with relevant codes, as this court knows, the mere compliance with codes or regulations or statutes doesn't necessarily mean that there isn't common law negligence. In light of, and then our second argument as against defendant Crew is that their motion for summary judgment was premature. The motion was made shortly after they answered in the case. They provided no discovery. They haven't produced a witness for deposition. Our brief and the underlying motion papers set forth a series of questions, among others, that we would ask a witness if we had the opportunity to do so. And we also note, and it's included on page 613 to 614, the two photographs showing the distinction between the sidewalk shed as it existed on the day of the accident and the sidewalk shed as it existed earlier, where those planks on the bottom weren't in that location. That's what Ms. Cardenas testified caused her accident, her inability to look down and see what was on the sidewalk in front of her.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Christopher Cafaro. I represent Betanzas, and I represent Wavecrest. What you didn't hear counsel dispute either, with all due respect, is the height of those planks, which our general manager, Ms. Mataroso, said was only 4 feet. She's 4'11", plaintiff is 4'11". I spent hours with this record. It's late in the day. I don't think that Judge Tewitt got one thing wrong in her pithy 6-page decision. She stated quite clearly, even drawing all favorable inferences to the plaintiff, the placement of the shed was not a proximate cause of the accident. Based upon the record, there is no indication that the accident occurred to any negligent construction of the sidewalk shed, but instead was caused by the unlawful operation of a motorized vehicle on the public sidewalk. The court cited this First Department case, Sherry versus United General Construction, which dealt with a vehicle going up onto a sidewalk. They sued the premise owner on a negligent design. I've cited numerous cases where vehicles have left the roadway and gone onto the sidewalk, which they're not supposed to do, and that's where the courts have said, in this instance, proximate cause is decided as a matter of law because we're not supposed to operate motor vehicles or motorized scooters on the sidewalk. It is a dispositive issue. In this case, we know from being in New York City that it's bad enough they're allowed on the traveled portion of the roadway, that you have to look very carefully. Sometimes they come out of nowhere, but they're legally there. On this sidewalk, shouldn't have been there. Plaintiff had left this, she lived here for about 8 years, and for the duration of the time that this sidewalk shed, which has to be there, it is there pursuant to a permit. It has complied with all of the requirements. Crew has put this one up and thousands like it in the city. Before it is taken down, there has to be a final technical inspection, which there was in this case, and I specifically copied that because it says it's on page 542, DOB accepted technical report. This is 5 days after the accident on July 30, safe condition, okay to remove it, and they removed it in August. I've cited the Margolin case, which is where the plaintiff was injured when a vehicle he was driving struck another vehicle at a car wash. They sued the car wash, claiming there were design defects there. The court said, nope, summary judgment. It was the two vehicles that are the sole proximate cause. I cited about 7 or 8 cases that are on point in the First Department. The 2 cases that counsel relies upon, they're night and day. They're night and day. The Second Department case, Curtis, it's what we call a double pole situation, right? That's where they're putting in a new pole and they're transferring the old facilities to the new pole. You're supposed to take out the old pole when that happens. A pole is 25 feet high, right? And the accident was on the roadway. It was between a motor vehicle and a
That's
motorcycle.
not our facts here. We
our-
got you. Thank you so much.
You know, Your Honor, I take things. A judge once told me that verbosity is not a virtue. And that wasn't that long ago. So I'm going to take that lead unless anyone has any questions of me. I'm going to give back my time.
I think we got it. Thank you.
Thank you, Your Honor. Pleasure. Pleasure.
Good afternoon.
Hi.
May it please the court, my name is Brendan G. Smith. On behalf of Defendant Respondent Crew Contracting of New Jersey Incorporated. Plaintiff's appeal asks this honorable court to overturn a summary judgment decision that was properly decided. It is this respondent's position that trial court's decision granting summary judgment to my client and co-defendant should be affirmed in all respects for 2 main reasons. First, the subject sidewalk shed that is the subject of this litigation was constructed entirely within applicable DOB guidelines. Chapter 33 of the DOB guidelines, specifically Section 7, so 3307, provides for protections for pedestrians who are entering and leaving active walkways. Under these laws, or these regulations, contractors are required to install a sidewalk shed for the protection of the pedestrians so they are not hit by construction debris or injured in any other way that construction work is being done. DOB guidelines, which called for the erection of this shed, were, so in support of their motion, plaintiff, in opposition to our cross motion or summary judgment.
Plaintiff's expert that they relied on, was he conclusory, was he speculative, was he
Both.
detailed?
Yes, both conclusory and speculative, as Justice Tewitt noted in her decision. And not an expert.
He was a superintendent.
Yes,
like
in an unrelated building in
another
Queens
building.
County. The co-defendant submitted an expert of a licensed engineer who went through the codes point by point to show that my client complied with all of the codes. Thus, there's no issue even regarding duty because my client fulfilled their duty under DOB guidelines. Second, and plaintiff had brought this up just now, is that no further discovery is warranted despite plaintiff's contentions. While my clients did not participate in a deposition, no deposition was necessary as no new material information could be gleaned from that deposition. In support of our motion for summary judgment, we submitted an affidavit of Saeed Ahmed, who is the principal for crew contracting, and in his affidavit, as well as is in co-defendant's affidavit, shows that they complied with all the guidelines for the Department of Buildings.
You can finish your statement.
So, just in conclusion, this decision should be affirmed. Thank you so much.
That's the statement, right. Okay, thank you. You have a minute.
Thank you. Counsel referenced the DOB report, which counsel for crew in their brief labeled a New York City Department of Building report. It was no such thing. It was a self-prepared document that was submitted to the Department of Buildings, as Betances concedes in their brief. On the
And
issue,
counsel, as we're talking about crew, you know, and the purported need for discovery, now, crew didn't even install the shed, right? Crew didn't
Well,
install the shed?
they didn't argue that in their motion, and it
No,
wasn't
I'm just,
subject
I'm
to
just,
the
yeah, but
review.
they,
No,
you know,
no,
they,
I bring that up to tell you that I don't know for sure, because we haven't done their deposition, and they didn't, it was mentioned in an affirmation,
Yeah.
but it wasn't a basis of their argument.
And they didn't, well, there certainly wasn't a complaint made to crew, it was made to the management company about the shed.
Correct, but notice is also not an argument that either side
wanted
made.
to ask.
And if I may just,
Thank you. We're done.